Good afternoon, everyone. My name is Baldev Binda from Blackstone and Gold in Singapore. Welcome to our webinar this afternoon on restructuring and insolvency. We've got a really exciting webinar today because we have got some of the best speakers from across the globe in terms of restructuring and insolvency. We have Mr. Marc Gillieron from Geneva from Chabrier Avocats, and we've got John Wang from Wang Jing Co in China. If you are like me, I think the past few months have all been about restructuring and insolvency, and many questions have jumped about. What is a JM? What is a scheme? What does Section 211B mean? What is a moratorium? What can I do? What I can't do? And really, these questions are what have fed and what have resulted in this webinar this afternoon. I'm very pleased to take you through the aspects of restructuring and insolvency for Singapore. I actually, thankfully, have the easy job of actually just talking about Singapore and the different court processes we have. Marc will be speaking about the Swiss attachments in Geneva. John, I think, has a more difficult task of explaining about the insolvency regime in China, but also with respect to enforcement of foreign insolvency proceedings in China. Let's get on to our webinar then. I've started with a bit of a brief overview of what are the options and what are the options in play when it comes to restructuring. And in front of you, you'll see a slide that presents effectively the three options. From the left hand, there's Section 2110, which is a scheme of arrangement. In the middle, you've got judicial management, and on the right, it's something we're all quite familiar with, which is a liquidation of a company. Where it gets confusing, really, it's the blue box, which is the Section 211B moratorium. That creates confusion because many parties think that Section 211B is independent or a standalone right for a restructuring mechanism. And if there's one thing you take away from this webinar, let it be this. Section 211B doesn't exist as a standalone. It is actually meant to be a moratorium to be used in conjunction with a Section 210 scheme of arrangement. So to put it in pretty layman's term, Section 2110 is for a proposal for a scheme of arrangement. Section 211B is a moratorium that seeks to protect the debtor until it's ready to put forward a Section 210 scheme. The characteristics are in the bottom below, the box below. And for a Section 210 application, think of it as a more comprehensive restructuring or protection. So Section 210 comes hand in hand with Section 211B, which is what we're seeing a lot of now. And the reason for that really is because it takes time to prepare a scheme proposal. If a proposal has to say it wants to do A, B, and C, that whole process takes time in terms of how the company is meant to restructure, what's going to be sold, what new assets are going to be coming in, what new capital injection will be coming in. And this time period could take a couple of months. And in that time period, we don't want a situation where the company is losing its assets, being stripped away of its assets because it doesn't have protection. That's where you get Section 211B to come in to protect the company, tide it over until such time that it gets its scheme papers together. What are the traits of a Section 210 and a Section 211B moratorium? So I've put it in red in the box below. In a scheme, the directors are running the company, and there is a stay on enforcement from the time a scheme is applied for. What a moratorium does is to enhance it by the blue bullets in the box as well. With the moratorium, you get an automatic 30-day moratorium. So from the time you apply for a moratorium, whether you're granted it or not, you automatically get a 30-day moratorium till the time the court hears whether you're granted it or not. Section 211B also comes with enhancements so that in protecting a company, a subsidiary can also apply for protection alongside the protection granted to a company. Section 211B also grants, well, I use the word extraterritorial effect, but might be a bit of a misnomer because it gives powers for these protections to be recognized worldwide. The big question is really, it depends on the foreign jurisdiction And I think my colleagues from Geneva and from China will tell you otherwise in terms of whether a foreign court might recognize these procedures. In a judicial management, which is in the middle, it's something we've seen in the past 2 months with some of the companies, and it's more suitable in a situation where there is concerns over the ability or the propriety of the directors acting in charge of the company. So a third party comes in the position of the company. It too gets an automatic moratorium. The key difference between a JM and a scheme, once again, is that a JM, a third party, is running the company, and that third party has got pretty extensive powers. It's got powers of review to look at whatever transactions that should not perhaps be entered into, maybe unfair preferences, maybe, undue preferences, maybe transactions at an undervalue. It has powers to obtain information from the company, from the directors, from counterparts. But on the downside, it's a natural consequence and an understandable consequence that it's going to take some time and it's going to take some costs to get a third party to run a company. Naturally, the JMs the judicial managers are stuck with a pretty unenviable task. They have to run the company, stave off claims, also try to pursue recoveries on behalf of the company. So all of this will take time and it will eat into the costs. In a liquidation scenario, I don't intend to touch on it on a great deal. I do mention 2 points, which is the powers of review, which is similar to the situation in a JM. A liquidator sits in the position of the company during liquidation, and it then tries to it will then review whatever transactions that might need to be unwound. Notably transactions at an undervalue or perhaps transactions that give an undue preference from one creditor to another. The key point about liquidation, where we hit a stumbling block in terms of the cases we see, is that it requires money to pursue for the liquidator to pursue these actions. And naturally, in a situation where there isn't sufficient money, where creditors are out of pocket with substantial sums, it is quite hard to get an agreement between significant creditors to put in more money, to throw in good money after bad, in terms of trying to recover a lot of receivables, or in terms of trying to to unwind transactions at the same time. Now, with the broad overview of your different options, I am going to focus on what is the key theme or the key flavor of a restructuring choice in Singapore, at least. And this is what I call the moratorium with the scheme. Now, everyone uses the word moratorium about, and I've tried to actually put it in a diagrammatic form, the flow of the different steps. I think it's critical to have this view because it gives you an idea, A, of timing, B, of the different stages by which objections may be made to the scheme, and 3 steps you can take to improve your position throughout this process. So how does it start? Back in the day, where there was no Section 211B a couple of years ago, all you have would be the Section 210 scheme, which is the flow in the blue color boxes. And that flow will go on from scheme till the time the scheme is approved and performed. But as I mentioned before, there was a gap between the time a scheme is put forward to the court and a company having its assets stripped or having claims pursued against it, such that it actually goes against the whole objective of a restructuring. That's why you have a Section 211B moratorium. So the Section 211B moratorium is in the red blocks flow at the bottom. And it starts with the moment you make an application under Section 211B. The company, protection against appointing receivers against the company for assets owned by the company or held by the company, and also protection against making the company applying for a liquidation of the company at the same time, or enforcing security. From the time, let's say if a debtor starts an application today, it has got an automatic 1-month moratorium, and that 1-month moratorium really is to give it that breathing space before parties go to court and argue whether it should be given that moratorium. So that's the second red box over there. You've got a 1 month period, and within that 1 month, parties need to go to court, and the court will decide whether the company's application should be granted. At the time of filing, we call this stage 0 perhaps. At this time of filing stage 0, the company needs to file an affidavit, and the affidavit should provide information in terms of the company's creditors, its exposure, both secured, unsecured, and in terms of its plan going forward. It may not be a concrete, comprehensive plan, because that only happens in the blue boxes, but it needs to give a brief overview as to how it intends to keep the company going. The test at this red box at section 211B is actually quite low. From the point of view of the court, it's actually just a case of giving it protection till the time the company is ready to form a scheme to put forward to the creditors. Now, the key thing about the second red box is that this is the time to analyze what has been put forward by the company, to strategize and to ask for information that is needed to understand, to weigh up the pros and cons in terms of whether to support the moratorium. For example, if a company applies for a 6 months moratorium, creditors may take the view this is far too long, they want a shorter moratorium. Creditors may ask for more information. All of this is done within the second box, within that second stage. What is often our experience is that the court will then grant conditions that have been justified by creditors. For example, information, for example, specific prohibitions on the company not to do certain things during this period. Because remember, ultimately, during the moratorium, it is a bit of a one-way street. The company is protected. There's nothing stopping the company from doing things, from conducting business in the ordinary course of business, from perhaps even disposing as assets in the ordinary course of business. And that's where I think creditors need to be quite sharp and quite focused on what exactly they want to prohibit the company during this moratorium period. At the time, when we move on to the third box then, once the moratorium is granted, let's say for a period of 3 months with certain conditions, then the company would be in a position, after 3 months, would be in a position to put forward a scheme proposal. And that scheme proposal will contain quite a detailed view of the proposal put forward for creditors to vote on. Generally, this proposal consists of 3 elements. Number 1, it would consist of some sort of cash injection, either by a white knight or either by stimulating some part of the business. Number 2, I think it's in terms of improving the recoveries of the company. And this is a critical point. It would be the case that by protecting the company is able to recover receivables. And receivables in trade finance, as we all know, it's one thing on paper and another thing in practice. The third thing would be a case of perhaps a business plan for the company. And this business plan might sort of downsize and focus on one specific product type instead of many different products. It might take a specific geographical focus on its trade and put forward that in terms of how it thinks that will sustain the business. So in a large part, it involves a lot of downsizing of its operation to reduce the cost and a focus on its business so that it can go forward. Once it's put forward its scheme, then we actually, that interlink between a moratorium and a scheme that happens. Parties then go into the blue flow. And the blue flow is actually where the critical steps are taken. And I've listed step 1, 2, 3 at the top. Step 1 would be an application for leave to convene the creditors' meeting. And we use this word leave in law, but in layman's terms, it actually means just permission. 1 or 2 cases we have seen where it's failed at step 1 would be in a situation where creditors have managed to show that the plan is doomed to fail. The scheme put forward by the company is doomed to fail. Large part because many creditors have grouped together and say that they haven't got the requisite majority to go to step 2. Why would a plan fail at stage 1? as I mentioned before, it would be the case of perhaps the creditors taking a view that any plan will be doomed to fail because a majority of creditors are looking to object and want to liquidate the company. Number two, the plan being put forward by the company is really perhaps lacking in sincerity, lacking in merit, perhaps. Number three, perhaps there's a lack of bona fides on the part of the company. Maybe it has done certain things during the months leading up to the restructuring, or even during the restructuring process, that give rise to suspicions on the part of creditors. And number four would be a general lack of information, perhaps. When there's not enough information as to the restructuring plan, creditors tend to want to object. If leave is granted by the court, then a timeline is given for a creditors meeting to be convened and voted on. This is typically quite a short timeline. It's not a particularly long timeline. And the key issue between stage one and stage two is that parties then submit their claims. They put forward their proof of debt. And the proof of debt will then in turn determine their voting rights. After the scheme has met the requisite approval, for example, 75% of the total quantum of claims have, the creditors holding 75% of those claims have voted on the scheme, then you get to stage three, which is basically the sanctioning of the scheme by the court. And that too, again, is another opportunity for creditors to object. It is a high bar to object because the scheme pretty much has been approved, has been voted on by all the creditors. So it would be the case of showing some severe, prejudice, or maybe something, a lack of regularity in how the scheme meeting was put forward. Once the court approves stage three, the scheme is then performed. So, for example, the scheme might say, the company needs 2 years to perform the scheme and make certain milestones each, maybe every 6 months. If a certain milestone is missed, there might be termination events leading up to non-performance of milestones. If the scheme is terminated, then all of it falls away. The scheme falls away, the protection falls away, and inevitably the company will go into liquidation, I suspect. This is a mind map of a flow from start to finish of a scheme using the Section 211 moratorium. I'm going to move on to security and where creditors stand with security, because this is a very technical subject, but it can have a huge bearing on both the restructuring and also in terms of how you vote on the restructuring. Now, the basic proposition is this: creditors with security cannot enforce security without leave of court. That doesn't mean they cannot enforce it, it just means it needs leave of court. And to get leave of court, typically speaking, you'll want to show that the security is specifically incumbent to you and will not prejudice other creditors. So at the top of the security chart, I've shown what are the more strongest securities, with the ones going down where it's the securities might not be as firm or as strong as the ones on top. So we start with mortgages. Mortgages are fairly secure, right on top. Doesn't happen too often in trade finance. Pledges is something that's very common in trade finance, and there's a bit of an issue between pledges and charges. If you were to pledge someone your car, you give them possession of your car. And so there's no need for you to tell the rest of the world that the car has been pledged, because the person driving the car is proof of that. Possession equals proof of the pledge in that sense. Charges, on the other hand, are invisible. They are invisible in the sense that no one knows whether a charge has been created in favor of a company. And that's why charges are registered or registrable under Singapore law on ACRA. And when charges are registered, what happens is that all parties, by doing an ACRA search, can see whether charges have been created by the company. Charges are visible to show that assets have been encumbered. Pledges are not visible because it works on a pretty archaic concept of possession. Where has it gone wrong in modern day trade financing? I think it's gone wrong because modern day trade financing with pledges works on constructive possession. So you no longer pledge a cargo of oil or a cargo of cashew. You actually take the BLs, and the BL is being pledged. And by giving the BL to the bank in the trust receipt function, then you're actually creating, effectively, you're creating constructive possession. You're telling the bank that here is constructive possession of the goods. Physical, actual possession of the goods is still in the hands of somebody else. And with this disjuncted flow, you're always going to have a situation where goods might move physically on one way, while a bank is holding on to the BLs that has been pledged to it. That's until this disjunct between pledges and charges are resolved, we are going to continue seeing some of the double financing cases carry on. I've listed assignments over there as another layer of security that is quite typical in trade finance. The one point I want to make about assignments is that you've got legal assignments and equitable assignments, depending on whether notice has been given. With legal assignments, you get to sue in your own name. With equitable assignments, you have to sue, the company has to sue on your behalf. And this can be problematic in the case of a restructuring, because you want to be able, as a lender, or as a creditor, you want to be in a position where you can dictate pursuing recoveries. I'm going to go on to fixed charges and floating charges, and there are a lot of interesting, real practical issues that happen from this. Let me start with fixed charges. Fixed charges would be the case of, to give you an example, maybe a deposit account there's a fixed charge over a deposit account. And the reason why it's a fixed charge is that typically the trait of a fixed charge is control. Without control, it cannot really be deemed in law as a fixed charge. So you might have a document saying this is a fixed charge for a bank account, but if you as the lender or creditor have no control over when money goes in, when money goes out, then I would say that the law is not going to deem it as a fixed charge and probably deem it as a floating charge. So control is essential for a fixed charge to be deemed as a fixed charge. When it comes to charges, you're looking at, the reason why all of this is important is because it places you on a priority, a sliding scale of priority in terms of where you rank in an insolvency, and by extension in a restructuring. The more secured you are, the better your position is in terms of getting repayment out of a scheme plan. Floating charges work on a concept of crystallization. So a floating charge allows, it only gets fixed when an event of crystallization happens. And an event of crystallization can happen either through law or through contract. So in contract, for example, a floating charge may become crystallized if you create automatic crystallization events. For example, the company tries to create another charge that over your floating charge, or certain events of default are done, and then the floating charge converts to a fixed charge. So that is an event of crystallization that will create will move a floating charge into a fixed charge, which gives it a higher priority. The one thing about floating charges that people get wrong is that they tend to think that in law there's a general freestanding rule that the moment you apply for restructuring, floating charges will convert into fixed charges. That's not really the touchstone of the law. The touchstone really is if a business ceases to operate, and a restructuring doesn't mean a business ceases to operate. I've got to move on to my last slide, and I think this is where the real practical considerations come in at the 3 different stages of a restructuring. Before the company applies for restructuring, most of the time they will go to creditors, and there will be meetings, and there will be attempts to repay or to create a restructuring plan before going to court to seek protection. And that's the time where I think it's really critical for lenders. It's really critical to enforce your security, to get more information, to put yourself in as best position as possible. If you have floating charges and you can convert them into fixed charges, now would be the time to do it. The focus at the pre-restructuring stage is looking out at preferential payments. Between 2 secured creditors, a debtor might pick to pay one creditor that it has a better relationship or has more pressure being put under it than another creditor. Between 2 unsecured creditors, that rationale will apply as well at the same time. That's where the focus needs to be at a pre-restructuring stage. It is to prevent the movement of money out in favor of one creditor rather than the other. That's where the focus needs to be. At the time a moratorium is applied, which is perhaps Section 211B, that's when we get the most queries, really. I think that's when everyone is concerned as to what they can do or what they cannot do. And the answer is pretty simple. Let's start with what they cannot do. They can't wind up the company, they can't start action against the company. If you recall, it's all one way. They can't appoint a receiver against the company, and they can't enforce their security except with leave of court. Now, I'm not saying that it's an absolute bar against enforcing security. Leave of court is required. And leave of court can be obtained if, for example, as mentioned before, a creditor can show that that security is specifically encumbered to it, and it will not prejudice any other creditors. The more practical issues comes in terms of new contracts and existing contracts. With new contracts, parties often think that the company is no longer in existence, they can't enter into business with it. I think that is incorrect, and I think that actually goes against the whole point of a restructuring. Business is meant to be done with the company. There is obviously a huge commercial payment risk. And that's where my advice would be that if you're taking on new contracts with the company and you're doing it on LC terms, on SBLC terms, then I think that payment risk is mitigated. And it's easier for a party to then enter into new contracts with a company that's going through restructuring. Just bear in mind, if the company is in a judicial management, that you really need the judicial manager to sign off on any new contracts. I've put LOIs over there, and this is a topic by itself that could take an hour. And LOIs are letters of indemnity that are used in modern day shipping to discharge cargo while the BLs are still in the banking channels. And the issues happen when there is a solvency risk on the party that is issuing the LOI and discharging the cargo. So for example, if company X is applying for a restructuring and company X is the one that's issued the LOI, then naturally there is a risk that that company wouldn't make good its claim under the LOI. I'm happy to speak about LOIs at a different time, but it is a technical subject, so I'll leave it at that. On existing contracts, I think most parties feel the psychological or knee-jerk reaction to terminate existing contracts once a company goes into restructuring. And my advice to that is that be very careful when doing that, in large part because the whole point, once again, of restructuring is to carry on business with the company while mitigating any exposure. If a counterpart wants to terminate existing contracts, it has to be very careful that it's allowed to do so under law. And that means looking at your contracts carefully. And most contracts will have an event of default clause that says that if a company applies for restructuring or appoints a receiver or has any insolvency proceeding started against it, that would be an event of default leading to termination. That's all good and proper, but do bear in mind that Singapore has passed a legislation that will come into force in a couple of months that prevent a party from using that clause. So if the only reason you want to terminate is because the company has gone into a restructuring, that legislation is going to prevent you from doing so. And when you're prevented from doing so, then you would be wrongfully terminating the contract and would be liable for wrongful termination in return. So the shoe goes on the other foot. The last final point I want to make about practical considerations when putting forward a proposal would be that too many times creditors seem to not apply their minds once they receive this bottom line conclusion that restructuring is always better than liquidation. I don't always agree with this, and I would ask creditors to test the proposal time and time again, right from the start, right till the end, till the time the scheme is voted upon. A proposal generally consists of these four elements. I put receivables, a capital injection, not injection, the business plan, and the valuation of the assets. The important point I want to make about receivables is this. Yes, on paper, a company might have hundreds of millions of receivables, but the real question is how likely is that recovery going to happen? When looking at a financial report, has the financial consultant who claims that the receivables are 100 million, has an analysis been done on how feasible that recovery is. That depends on which countries the receivables are due from. What are the likelihood of enforcing the receivables in those countries? Bear in mind, counterparts dealing with a restructuring company are not going to be particularly keen on paying on their receivables, because when it comes to capital injection, the point to look at that would be really to see the credibility of this promise of a capital injection. Why would someone inject capital into the company? What's the benefit for them, for the white knight to come in? The third point would be the business plan created by the company. And I think, once again, this is something that not enough time and effort is used to apply in terms to analyze what this business plan is, how feasible and how practical it is. And I would advise creditors to spend some time looking at it. And where there are questions from all of this, and there will always be questions, that is the time to go to the debtor and ask these questions. And if you don't get the answers, this is why the court process is there. You then can get the court to order, if reasonable, the court, and if the court agrees with you, the court can then make any moratorium, make any scheme subject to these conditions, that certain information is provided. And I think that would give everyone a holistic picture, so that they have all the information they need before they vote at stage 2 of the scheme meeting. That is it for my part. I think it's much longer than I expected, but I think it gives you a comprehensive overview of the restructuring and insolvency court processes in Singapore. I'm now going to hand over the presentation to my colleague Marc Gillieron in Geneva, who will speak about the Swiss attachments that can be considered for debt collection. Thank you and have a good day.
Hello everyone, my name is Marc Gillieron and I'm a Swiss lawyer and a partner at Chabrier Avocats in Geneva, Switzerland. I'm going to talk today about the Swiss civil attachment, in particular in the context of international recovery or insolvency proceedings. The starting point is, as you all know, when your debtor is on the verge of bankruptcy or insolvency, it is usually wise to try and secure or improve your position as a creditor or your exposure as quickly as possible. Speed is key. And this is where the Swiss civil attachment comes into play. The attachment, that is also known as a freezing order, can be defined as an interim measure aiming at securing the later enforcement of a claim. And that's very important. As a rule, the attachment does not grant the applicant any preferential right over the attached assets. And this is why it can be extremely helpful in the context of foreign or international insolvency proceedings, because it does not give the applicant a preferential right on the assets that are being attached compared to the other creditors. It simply avoids the dissipation or the concealment of assets, also to the benefit of all creditors. And in this respect, it is seen as being compatible with insolvency proceedings that are being conducted abroad. So the Swiss civil attachment has two main characteristics that make it quite unique when you compare it to similar measures that are available in other jurisdictions. The first characteristic is that it is available even pre-judgment, which means that you do not need to obtain a final judgment or award before you can start enforcing your rights and securing your claim. So you can do that immediately after the claim upon which the attachment is based becomes due. And that's a very big difference with most of the jurisdictions, which usually require that the creditor holds a valid and final judgment before it can apply and obtain a freezing injunction, blocking the assets of its debtor. Unless, of course, the creditor can demonstrate that the matter has a certain degree of urgency. And this is the second main characteristic and main difference of the Swiss attachment. It's simply that there is no condition of urgency. In other words, the creditor does not need to show to the court that the debtor is concealing or dissipating its assets, or that more generally the claim is in danger. So, and that's very, very particular. It's unique, and in most of jurisdictions, if you can obtain a freezing injunction pre-judgment, you need to fulfill the condition of urgency. In Switzerland, we have no condition of urgency, and the attachment is available pre-judgment. So that makes the attachment quite unique. Among the other main characteristics, one can mention that the attachment is granted ex parte, which means that you can obtain the measure without the debtor being heard by the court, which is very important in order to preserve the effect of surprise. There's a relatively low evidence threshold, which means that you do not need to prove your claim. Very strictly speaking, you simply need to show to the court that it's likely that your claim is due and that the other conditions are met in your case. So that's a very, very important thing. Evidence is limited to likelihood. It's also very easy to obtain. It's quick and it's inexpensive. The order can be obtained within 24 to 48 hours from the moment of the application, and it usually costs around the equivalent of $2,000 in court fees. So it's quite easy to obtain, quite inexpensive, and easy. So the fifth characteristic, and that's an important one in the context of international proceedings. The attachment does not create jurisdiction in Switzerland for the claim on the merits. In other words, if your claim is based on a contract and that the contract contains a jurisdiction clause, this clause will remain valid and will prevail, meaning that when you will have to validate the attachment, because any interim measure, it has to be validated once it's obtained, then this validation will happen before the courts that are competent under the relevant jurisdiction clause of the contract. So that's a very important characteristic. And finally, the attachment is available even if the debtor is insolvent or bankrupt, even if bankruptcy has been adjudicated. In the home jurisdiction of the debtor, the attachment remains valid and available. So that's very important, because it means basically that you can try to enforce your claim in Switzerland, if you can identify assets of your debtor in Switzerland, you can try to block these assets for your benefit, of course, but also for the benefit of other creditors. So these assets will remain blocked, and potentially they may be distributed to you as a creditor that has obtained an attachment, at least until the foreign insolvency decision or the bankruptcy decision is recognized in Switzerland. And this is subject to a certain number of conditions, so it's not automatic, requires that a certain procedure be followed, and it's not always recognized. So it means that in certain circumstances, the assets that have been attached can be released in favor of the creditor that has obtained the attachment, even if the debtor is insolvent or has been declared bankrupt. So that's a very important element. Now, just coming quickly to the conditions of the Swiss civil attachment. Well, as I said, and obviously you need to have a claim as a creditor, so you need to show to the court that it's likely that your claim is valid and that it's due. So these are really the two conditions, the main conditions that apply with respect to the claim. The claim can be, the cause of action can be any of any type. It could be contract, tort, breach of fiduciary duties, or anything else. As I said before, the evidence threshold is limited to likelihood. So you don't need to come up with this, strict evidence. It can be, any type of evidence available under Swiss law, but again, limited to likelihood. So the threshold is quite low, actually. The second condition is that the claim should not already be secured by way, typically, of a pledge, but a pledge in Switzerland only. So if you hold a pledge over certain assets outside of Switzerland, then you can still apply and obtain an attachment. Third condition, and that's very often the tricky one, you as an applicant must identify the assets that you want to attach. Typically, you will try to attach, a bank account or an immovable asset, like a real estate property, but you will have to identify those assets. They can be the identification can be quite generic, but of course there's a prohibition in Switzerland of fishing expeditions. So you must come up with certain documents showing that it's likely that the assets that you have identified do exist. Typically, if you want to attach a bank account, you don't need to provide the court with the bank account number. It's sufficient that you show that typically the debtor claims having a bank account with that bank. We often see on websites, typically of companies, that they do have banking relationships with a certain number of banks, and that is considered as a sufficient evidence in order to attach the bank account and obtain an attachment of the bank account in Switzerland. So if your debtor claims on its website that it banks with Bank X in Geneva, that is sufficient. Of course, you can use an invoice. That is also a sufficient evidence. A bank detail, banking information that is contained in a contract, that is also sufficient. I mean, all these circumstantial evidences are deemed sufficient under Swiss law in order to obtain an attachment of assets. And finally, and that's of course the key condition, the applicant should demonstrate the existence of a so-called attachment ground. So there are different attachment grounds under Swiss law, but the most important one and the most frequently used is the following. It's the debtor is not domiciled in Switzerland, which obviously is often the case. And then you have two subconditions, provided that the claim has sufficient connection with Switzerland, or the claim is based on a recognition of debt. So in most cases, you will try to base your claim on a recognition of debt. So the meaning is it looks narrow on the face of it, but in fact, it's much wider than one could expect. The definition of a recognition of debt is basically a commitment signed by the debtor to pay a certain amount of money at a certain time. So typically a loan agreement is considered as a recognition of debt. Even a sales contract can be considered as a recognition, or can be accepted as a recognition of debt if the buyer commits or undertakes to pay a certain amount of money at a certain date. So that is sufficient. So as long as you can come up with either a loan agreement or a sales agreement or a guarantee or all these type of things, then this condition is accepted by the court, and you will be able to obtain an attachment. So to summarize, we have seen that the attachment is available pre-judgment, without condition of urgency, that it's obtained ex parte, that the evidence threshold is quite low, and that it's quite quickly obtained. It's easily and quickly obtained, inexpensive, and does not create jurisdiction. So all these features or these characteristics make the attachment a very useful tool when it comes to securing your position as a creditor in the context of international recovery or insolvency proceedings.
Hello everyone, I'm John Wang from the Chinese law firm Wang Jing Co. Taking this chance, I will talk about what would happen if creditors would like to enforce the debts owned by someone who might be in an insolvency condition in China. We will first have a quick introduction on the basic idea of Chinese bankruptcy law, and then we would move on to creditors' consideration and actions before or after debtors' defaults. Basically speaking, under Chinese law, only enterprises can enjoy the protection of bankruptcy. No individual can enjoy such privilege, except for that in most parts, Chinese bankruptcy law is similar to other popular jurisdictions. Both debtors and creditors, and actually in some circumstances even shareholders, can apply with the court for bankruptcy. When initiating the proceedings, the applicants can choose either to liquidate the company or restructure it or achieve a settlement. After the court accepted the application, the court would appoint administrators, and in most circumstances, administrators would take over debtors' business, even in the restructure process, and this is quite different from U.S. Chapter 11 proceedings. After the court acceptance, there would be an automatic stay of legal proceedings, attachments, and enforcement. After the start of bankruptcy proceedings, some transactions can be nullified or avoided by the administrators, and the principle of pari passu would be applied in distribution of the assets. When the court decides whether to accept a bankruptcy application, they would adopt two tests, either the cash flow test, i.e. the debtor is incapable to repay debt due, or the balance sheet test, whether the assets owned by the debtor can't meet the overall liabilities. So, after the court accepted the application, the administrator would take control of the company and make investigation into or trace debtor's property. There would be an automatic stay of the legal proceedings, enforcement, and attachment. Undue debt would be accelerated and floating mortgage would be crystallized. Creditor's right would be converted into the right to register and prove. And lastly, the clock would start to tick retrospectively for avoidable transactions. Of course, the interest would stop to accrue. Generally speaking, the basic process of bankruptcy proceedings would be like this. Court would review the application and decide whether to accept it or not. If the court accepts it, the court would appoint an administrator to take control of the debtor. The administrator would make thorough investigation on the property of the debtor, and in the meantime, they would request the creditors to register the debts. They would also prepare the distribution plan or restructuring plan and then present them for the approval of the creditors and the court. In case of the settlement proceedings, the settlement plan would be prepared by the debtor in application rather than by administrators. After the plan is approved by the court, the plan would be executed. When distributing debtors' assets, the ranking of the unsecured claims in the bankruptcy proceedings would be in below sequence. Firstly, the bankruptcy expenses. Then comes common interest claims, employee salary and benefit, tax, and other unsecured claims would be paid lastly. So, based on above background before the default, what a creditor needs to consider? First of all, you need to know your right. Two most important things are security and property. You need to know what kind of security will be recognized under Chinese law and whether the court would accept that you own a property in some special circumstances. The securities Chinese court would recognize would include mortgage, including floating mortgage, pledge, not only on tangibles but also on bill of lading, instruments, receivables, or other choosing action, lien, including possession lien and statutory lien, and other statutory security created by law. Secondly, you need to know your risks. The major concern would be avoidable transactions. This would generally fall into two categories: fraudulent transfer and preference. For fraudulent transfer, the administrator can avoid the transaction if the transaction happened within 1 year from the date that the bankruptcy application is accepted by the court. The fraudulent transfer mainly concerned about the lack of consideration and would include no consideration at all, substantially and value, provide security for unsecured debts, making payment when debt is still undue, and waive the claims against the creditors. Preference means to make payment to the creditors in executed contract, unless the debtor has obtained benefit from the payment. These transactions may be avoidable if conducted within 6 months from the date of accepting the bankruptcy application. So, for example, you sold some masks to D. Under the sale contract, D would pay contract price 3 months after he received the masks. After he received masks, D paid you, but after 5 months from the date of payment, they go to bankruptcy. Then the payment might be viewed as preference payment and can be avoided by the administrator. After debtors default, the creditors need to consider what would be their best chance to recover their losses. The basic strategy or actions in Chinese scenario would be not include. Firstly, you need to take back your property as soon as possible. Your property also includes the goods kept by the debtors and the bailment, the goods sold on reservation of title if the debtors hadn't paid the majority of the price, the goods in transit which hadn't taken delivery by the debtor. If your goods or property destroyed or lost, the insurance indemnity or compensation received by the debtor as the compensation for the loss. Secondly, you can consider offset or letting. This is allowed under Chinese bankruptcy law. You also need to consider enforcing your security as soon as possible. The enforcement of security is stayed after the bankruptcy application is accepted by the court, but you can enforce the security in the liquidation or settlement proceedings after the administrators have taken control. In restructuring process, normally the enforcement of the security would be delayed during the period of restructuring. When your contract with the debtor hasn't been fully performed yet, you need to consider the status of the contract. The administrator would have to have the say. They would either choose to terminate an unfavorable contract, and then your right in the contract would be converted to the right to register and approve. They can also affirm the contract if it is to the benefit of the debtor and unsecured creditors, but you can request them to provide the security for their performance. If they refuse to provide security, you can terminate the contract. The last part would be to seek recovery in the bankruptcy proceedings. You need to register and prove your debt. you need to vote for or against the plan, and you can also choose to favor one of the three routes of the bankruptcy proceedings. Basically speaking, as the security right would cease to be enforced in restructuring period, if you are unsecured creditors, you may consider choosing restructuring. Otherwise, you may choose liquidation or settlement. Of course, you need to consider other factors for your decision, such as the time to get paid and the costs for the proceedings. Thank you very much.